If you're watching this, you may be thinking about starting a new business, or you may already have one and want to make sure it's set up the right way. There are a lot of legal decisions early on that can have long-term consequences, and many people don't realize the risk that they're taking until something goes wrong. I'm Charles Houghton, an attorney at Black, Blink & Associates, and I've been practicing business law for over 40 years. My goal today is to talk about some of the key things to consider, what decisions should be made, and why using an attorney can avoid costly mistakes.
What's the very first legal step someone should take when starting a business?
The very first step is choosing the right business entity. Whether it's an LLC, a corporation, a partnership, or a sole proprietorship, that choice impacts your liability, taxes, and your ability to grow and bring on investors later on.
How do you know which entity is best?
It really depends on your goals. An LLC gives you flexibility and liability protection. A corporation may be better if you want to raise capital or bring in outside investors. Sole proprietorships and partnerships are simple but riskier because your personal assets are on the line.
Why is limited liability protection such a big deal?
Because it separates your business life from your personal life. If your business gets sued or has debts, limited liability means your personal assets, your home, your savings, are protected. That is assuming, of course, that your company is properly set up and operated.
What are bylaws or operating agreements, and do owners really need them?
Yes, absolutely you need them. Bylaws and operating agreements provide the written agreement about how the business is run. They cover ownership, decision-making, voting rights, what happens if an owner wants to leave, and other business matters. Even single-owner businesses benefit from these documents. These documents provide legitimacy to banks, investors, and courts, and they help prevent fights before they even start.
What's the difference between bylaws and an operating agreement?
Bylaws are for corporations, and operating agreements are for LLCs. Both outline how the business will be run, things like voting rights, profit sharing, and decision-making authority.
Can business owners just use free online templates?
They can, but it's risky. Templates can be dangerous. They aren't tailored to your business, your goals, and may not even be tailored to Colorado law. If you don't understand what the template means, you can be creating problems without even realizing it. A custom document ensures you're protected and that the rules reflect your actual business plan.
What happens if business partners don't have an agreement in place?
Without an agreement in place, disputes tend to get messy and expensive fast. Without an agreement, state law controls, and often the outcome is not what the partners would have wanted. It gets expensive, is time-consuming, and could result in lawsuits, failed businesses, and ruined relationships. These outcomes can largely be avoided with properly drafted bylaws or operating agreements.
What about licenses and permits?
It depends on the business and where it operates. You may need a general business license, state or local sales tax licenses, zoning approvals, or professional licenses. Skipping this step can lead to fines or even force your business to shut down.
How do taxes differ between an LLC and a corporation?
LLCs are usually pass-through entities, meaning profits are taxed on the owner's personal tax return. Corporations, unless they elect S-Corp status, face double taxation, once at the corporate level and again on shareholder dividends. There are pros and cons to each type of entity and its taxation. This decision should be made with both your attorney and your accountant working together.
If someone wants to raise money, what should they know legally?
Raising money means complying with securities laws. Having the right structure and agreements in place protects you and helps your investors take your business seriously. Failing to follow these rules can lead to serious legal consequences, including both civil and criminal liability.
How do business owners protect their name and brand?
Businesses can protect their name and brand by registering their trade names and trademarks at the state and federal level. Federal registration provides nationwide protection.
Do business owners really need written contracts with customers and vendors?
Without a doubt, contracts set expectations and protect you if something goes wrong. They're your first line of defense in a dispute. Whether you provide the contract or the other party does, it should always be reviewed carefully to make sure that there are no provisions which will cause problems later on.
What contract terms matter the most?
Some of the most important terms are clear identification of the parties, payment terms, scope of work, confidentiality, dispute resolution, and termination rights. A well-written contract signed by all of the parties can prevent disputes or help resolve them efficiently. They are worth their weight in gold.
What is intellectual property and why is it important?
Intellectual property includes things like trade names, logos, products, processes, and ideas. Trademarks, copyrights, and patents protect your most valuable assets, your ideas, products, and branding. Without protection, competitors may be free to copy it and use it themselves.
What employment law issues should business owners be aware of?
You need to comply with wage laws, proper classification of workers as employees or independent contractors, workplace safety, and discrimination laws. Mistakes in this area can be very costly.
Should employees sign any agreements?
Yes, offer letters, confidentiality agreements, employment agreements for certain employees, and depending on your state, non-compete and non-solicitation agreements all help protect your business. Recent changes in the law make careful drafting of these agreements especially important. A good attorney will make sure that you include everything necessary and exclude anything that may harm the business.
Are employee manuals necessary?
Employee manuals are not necessary, but they can be very helpful. A well-drafted manual sets expectations for such things like work hours, paid time off, vacation, discipline, termination, and a bunch of other matters. A strong employee manual can provide a great deal of protection to the business and to the employees alike.
What should an owner do when bringing in a new business partner?
You should follow the procedures in your operating agreement or bylaws first. Once the new owners are in, you'll need to update those agreements to reflect the new ownership percentages, voting rights, profit sharing, and exit rules.
What is succession planning and why does it matter?
It's planning for retirement, disability, or death. Without a plan, a business can quickly collapse or end up in court battles. Having a succession plan in place avoids a great many headaches and potential lawsuits.
What does piercing the corporate veil mean?
It means the business loses its liability protection. If you mix personal and business finances or ignore corporate formalities, a court can, quote, pierce the corporate veil, making you personally liable for the business's debts and obligations. Following corporate requirements is critical to avoid a piercing of the corporate veil scenario.
When should someone consult with a business attorney?
You should consult an attorney anytime you're forming a business, drafting agreements, raising capital, hiring employees, or facing a dispute. Fixing problems later is almost always more expensive than doing it right from the beginning. The time and money spent on an attorney in these stages almost always pales in comparison to what fixing the problem will cost.
What's the difference between an S Corp and a C Corp?
An S Corp avoids double taxation by passing income directly to shareholders, while a C Corp pays taxes at both the corporate and shareholder level. An attorney can help you choose which type to use depending on your size, goals, and tax strategy.
What's the role of a business attorney versus an accountant?
Attorneys focus on structure, compliance, contracts, and risk management. Accountants focus on financial reporting and tax filings. You'll need both, but for different reasons.
What is most important to know when setting up a business?
The main takeaway is this: invest in setting your business up the right way from the beginning. It saves time, money, and stress down the road. Online solutions sound appealing, and they make it sound easy. But these online forms simply cannot take the place of getting competent legal and tax advice. Better to spend the money up front than to regret it later. It is money well spent. If you're facing something serious, you don't have to handle it alone. We're here to help explain your options, protect your rights, and help you move forward.